Hi, I'm Noah Weisberg.
And I'm Doreen So.
Welcome to Holland Estates. You're listening to episode number 583. How are you, Doreen?
I'm good. How are you?
I'm doing well, thanks. So, today we thought we would talk about the oppression remedy. And for most of our viewers and listeners, you're probably thinking to yourselves, why would two estate lawyers be discussing oppression remedy on an estates podcast? And so, Doreen, you and I were going back and forth because we do see the oppression remedy show up sometimes in our files, and it's an important idea and legal concept that estate trustees and estate lawyers, we came across this great case which really simplifies oppression remedy, and it's just a great 101 to whenever you have to approach this kind of issue. This is a really helpful case to have in your back pocket. So the decision is Corber and Henry, and the citation is 2019 ONSC 3518, and it can be found on Canley.
And we'll post the link to the decision on our blog as well. And, the reason why oppression remedies should be part of the estate lawyer's toolkit, or at least be something to be aware of in terms of whether or not you need to pick up the phone and retain corporate counsel to consider it, is because shares of a company are very often an asset of an estate.
Exactly. Yeah.
And a lot of the times, beneficiaries have shares in the same company as the estate. And we've also seen oppression remedies being exercised by beneficiaries as against the estate trustees who are voting a different way than they would like. So in this particular case, Corber and Henry, it is a June 2019 decision of the Honorable Justice Chiapata.
Yes.
This is not an estate matter whatsoever. This is like a very purely corporate issue as between the three people who happen to own this one numbered company.
Yes.
But I think our firm also have a bit of a personal connection to the case as well, because the company that is at issue owns the building where the Artful Dodger, which happens to be a bar in downtown Toronto.
Yeah, which some of our colleagues frequent.
Yes. So, I mean, if you ever want to maybe meet one of us in person and have a beer, we're now more interested in supporting the Artful Dodger than before.
Yes. So, Doreen, perhaps you want to just give a bit of context with respect to the corporation and what the decision was by the corporation and what led to the lawsuit.
Right. How this whole thing actually came about was because there's a couple, there's a husband and wife, Henry and Koppelman. They own the Artful Dodger. They've owned it, they've ran the bar since 1989. But the opportunity to actually buy the building that they were leasing space from came up, and it came up in 1997, but the couple didn't have enough money just for the two of them to buy this building. So a close friend of them, Mr. Corber, decided to buy it with them.
Yeah.
And then in that way, and for this very specific reason, the three of them started a numbered company.
Yes.
This numbered company, the three of them have equal shares, the three of them have equal votes, and the three of them put in the exact same amount to purchase the building. And the company, at the end of the day, only owns this one asset.
Yes, and importantly at the time, although they did retain counsel, there was no shareholders agreement that was entered into. I'm not sure if you're going to discuss that if I just jumped your backstory, but I'm doing it.
Yeah, go for it. And because there's no real shareholders agreement, there's three people, so there's always like sort of like a majority rules in effect, right? And then two of the people, they're married, they run a restaurant, and the third person is just, their investor in a way. But the three of them have sort of been running this business fairly successfully, at least like for quite some time, until the land itself became just so enticing to developers that Corber got an offer from a developer to buy the building for $13.5 million in 2019. And that sort of difference of opinion in terms of whether or not the company should be selling the building to the developer versus just staying in place, running the restaurant as is, just collecting the suite rent until the end of time or until the next and better offer comes. This is where the oppression, or at least in Mr. Corber's view, came up.
Yes, exactly. So basically, Corber wanted the court to either accept the offer and sell the property to the developer, or alternatively, that the husband and wife buy out Corber's share of the corporation in a proportionate amount of what he would have gotten if he had sold it to the developer. So one of the bases that Corber relies on is the oppression remedy, and this is where, again, getting back to the beginning of our podcast, where Justice Chiapetta really sets out quite succinctly what the test is, and it really is a two-part test. So the court first has to decide what the reasonable expectation of the parties were, and that's based on the objective standard. And then once the court determines that, they have to decide whether the conduct violated that expectation. So fast forward, Justice Chiapetta looks at what Corber's reasonable expectation was, and finds that there was some sort of idea that the corporation would continue, and that the conduct of the husband and wife was not oppressive. It wasn't oppressive, unfairly prejudicial, or unfairly disregarded the interests of the security holder.
Right.
So on that basis, it was dismissed, and I guess to this day, the Artful Dodger continues. So I think that concludes our podcast for today. Until next time, we want to thank you for listening. I am Noah Weisberg.
And I'm Doreen So.
Should you have any questions, please email us at webmaster@townhall.com or leave a comment on our blog. Thank you, Doreen.
Thanks.